Welcome. The right to personal data protection and privacy is one of the fundamental human rights. With the rapid development of digital technology and the Internet, this right has been seriously undermined. In this part, we will understand the importance of privacy policy in digital use to report how personal data is used. In terms of existing frameworks, the European Union's EU 2016 General Data Protection Regulation (GDPR) is the most recent example of comprehensive regulation of data protection and privacy, setting a new threshold for international good practices. Building upon existing principles, example, the OECD Privacy Principles, it has become an important reference point for global work in this area. Article 5 of the GDPR enshrines the core principles described above, requiring that personal data collection, storage, and use be processed lawfully, fairly, and in a transparent manner in relation to the data subject. Collected for specified, explicit, and legitimate purposes. Adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Accurate and, where necessary, kept up to date. Kept in a form that permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed, and processed in a manner that ensures appropriate security of the personal data. In addition, EU member states are required to provide for a supervisory authority to monitor the application of the regulation. However, many member states had previously established their own supervisory authorities under the EU Data Protection Directive, the incumbent EU data protection regime. Some of the newer rights and duties it introduced when the GDPR took force in 2018 remain the subject of debate in policy circles, and a number of legal questions remain about their application in practice. However, the framework's key principles largely have their origins in earlier European law and are not new or specific to Europe or the GDPR. They are reflected in one form or another in many national data protection and privacy laws outside Europe, largely due to general recognition of their merit. The OECD has long played a pivotal role in developing policies for the protection of personal data. The 1980 OECD Privacy Guidelines were the first internationally agreed privacy principles. Updated in 2013, they remain an essential benchmark, including for the OECD's internal rules and practices. This page describes those rules and practices, which apply as well to the entities and bodies within the OECD framework such as the International Energy Agency, OECD Nuclear Energy Agency, International Transport Forum, and the Multilateral Organization Performance Assessment Network. The OECD and the entities and bodies within the OECD framework process personal data in the course of delivering their respective public interest missions. For example, the OECD processes personal data to manage and provide benefits to staff and as part of its recruitment and procurement processes. It also processes data regarding users of OECD websites, which is described in the privacy policy, and visitors to the organization as described in this notice. Similarly, the entities and bodies within the OECD framework may process data as described in the privacy policies on their respective websites. Other types of processing include data needed to facilitate participation in meetings and events, and to access and comment on documents. Personal data may also be processed as part of the evidence-gathering process to support policy making, for example, through surveys of individuals such as PISA and assessment platforms such as PILA. Such data uses may be the subject of separate data protection notices as appropriate. All staff are obligated to implement transparent and appropriate measures to protect individuals in relation to the processing of their personal data. The OECD data protection rules are set forth in the decision of the Secretary-General on the protection of individuals with regard to the processing of their personal data rules. The rules, which apply to the processing of personal data by or on behalf of the OECD, are included in Annex 12 of the Staff Rules and Regulations. The rules require that personal data be processed in a transparent manner for legitimate purposes to deliver the relevant mission and work program. Personal data are to be adequate, relevant, kept up to date, limited to what is needed, and retained for no longer than necessary. The rules also require that the responsible staff ensures that contractors processing personal data on OECD's behalf provide guarantees on the implementation of appropriate technical and organizational measures. There are significant limitations related to the processing of special category personal data, and for high-risk processing. Risk assessment is mandatory, with data protection by design and default integrated into the process. Security risks are addressed through technical and organizational measures reasonably appropriate to the risk. In the event of a personal data breach, notification requirements would be triggered. Personal data can only be transferred outside the organization subject to appropriate safeguards that should ensure, in particular, effective data subject rights and legal remedies. Some examples of national data privacy rules. The Estonian Data Protection Inspectorate, founded in 1999, is a supervisory authority, empowered by the Data Protection Act, Public Information Act and Electronic Communication Act. The Inspectorate's mandate is to protect the following right enshrined under the Estonian Constitution, which includes right to obtain information about the activities of public authorities, right to inviolability of private and family life in the use of personal data, and right to access data gathered in regard to yourself. Madrid Resolution of 2009 adopted by Data Protection and Privacy Commissioners 50. The 2009 Madrid Resolution 14 was the result of joint work by data protection authorities in 50 countries under the leadership of the Spanish Data Protection Agency. It is intended to provide a model incorporating universal standards of data protection, thus covering data protection values and principles that are safeguarded on 5 continents. 51. In addition to standard aspects of data protection, this resolution contains new elements such as proactive measures, procedures to detect and prevent security breaches, appointment of a data protection officer, privacy impact assessments, etc., and the accountability principle, which calls for internal arrangements that can be used to demonstrate that the controller is complying with data protection rules. Turkey protects personal data with purpose and scope of the Personal Data Protection Law No. 66/98. The purpose of this law is to protect fundamental rights and freedoms of people, particularly the right to privacy, with respect to processing of personal data and to set forth obligations, principles and procedures which shall be binding upon natural or legal persons who process personal data.